How's it going, everybody? Welcome to another episode of the Justice Revolution. Happy Valentine's Day, y'all. Yeah,
Oh, it's
happy
Valentine's Day.
Valentine's. Yeah, it's the 14th day of February in the year of our Lord 2025. So yeah, it is Happy Valentine's Day. So anyway, I am James the Patriot. I'm your host today for this show. Obviously, got my ever so faithful co-hosts. I got Erica. Erica, what's new? Say hello.
Hey, just prepping for the spring, getting really excited.
Oh, geez. Yeah, we just got pounded with a spring storm, right? Right, Justice?
I was going to say spring. We just got 1.5 feet of snow. It's midwinter here.
We've been spoiled. At least I have. Justice, she gets snow no matter what. But where I'm at, we've been spoiled because we haven't had like any standing snow or sitting snow for that matter.
It's been pretty light here, so I feel lucky as compared to 2 years ago. So
I guess I thought my joke was funnier than what it really was.
Yeah. You're sleeping snow.
Or the sleeping snow, right? Yeah. So anyway, yeah, we've been spoiled. So it came down on us pretty good last night, but you know what? The funny thing is it's all but melted now, at least where I'm at. So anyway, yeah, guys, sorry. It's again been a few weeks since we've had a show. A lot has happened. I have been really working heavily on helping some people. We're going to go over one of those examples today. The title of the show is A Real World Case Example of Vacating a Void Judgment. We're going to go over that and what that looks like. I got some updates. I've got another gentleman who was referred to me by a mutual friend of all three of ours. And he was I think he technically still is being prosecuted by the federal government, where they're trying to throw him in prison for 18 months. When you see this man, when you talk to this man, it's clear that this man has committed no crime at all. So anyway, where we are with his is that he was sentenced and he is supposed to report to the Bureau of Prisons next Friday to start his sentence. However, we filed a motion to vacate the sentence due to ineffective assistance of counsel, which that's going to be a lot of fun to go over, guys. Oh, I love that one. Ineffective assistance of counsel.
Mm-hmm.
And then we also filed an ex parte motion to stay the execution of that sentence. So ex parte just means, hey, this is a pressing issue. We need the court to rule on this without giving the other side a hearing. So we're hopeful, everybody, that both of these motions are granted and that we can get this guy the justice that he deserves, which is to get these people off his back. So that's where that is. Let's see, what else? The high school basketball season is almost over, and I cannot freaking wait. I'm so done with this. So, you know what, Rick? Come on, man. I was getting there. You didn't have to throw it in my face. Yes, we were actually talking earlier, and I apologize. It's taken longer than what we wanted to. I'm sure, as you guys know, when I've had people who have come and they ask for help, I got to devote what it takes to help. I am not a good multitasker. That's why I have Erica and Justice on my team, because I can't multitask. like Erica's over there. She's homeschooling her kids. She's nursing a baby, and she's on here. She's doing all three of those things at the same time. And Justice is the same way. Homeschooled all of her kids, but when folks have reached out asking for help, I've had to divert my time from the site, from our association, to that. Justice, God bless you, and you too, Erica, for being willing to step in and help out when you've had the time. We're just trying to get a couple of pages filled out. Now we know that most of our followers know who we are, what we're about. So you don't need to go to the website and learn everything that we're trying to do or accomplish. You guys understand that. You just want to be part of the family, want to be part of the association so that we can grow and we can fight these fights together. We totally understand that. Nobody is chomping at the bit more than I am. Mainly because, well, you guys already know. You guys know the situation. So we are working as tirelessly as we can My web designer is a fantastic gentleman. He's had some health issues. Either he has or his wife, or I can't remember. And so he hasn't been able to finish things as quickly as I would like him to, but he still gets the job done, and he does a great job. I have no qualms with what he's doing. So Rick, thank you. It's coming. Can't wait to read your book.
Yeah.
I know you said you sent a copy. Let's throw a little teaser out there for Rick. You got any information on that, Justice?
Well, we can go to the I totally forgot about that. Rick, I would have had that up already. Let me see what I can find on our Telegram chat. I'll pull it over and you can keep on talking.
Yeah. So while Justice is looking for that, there's I want to start off. Well, I don't want to get too deep into what I'm starting off on, but I've had some fascinating aha moments, revelations, whatever we want to call them, the last couple of weeks. And I think there's a lot of things that we're gonna talk about today that hopefully will resonate, and you guys will see and understand. Oh my gosh, the same thing is happening to me too. And I want to talk a little bit about those pesky. Let's see if I have one. Yes, pesky debt collectors. We all get these stupid things in the mail, right? And we talked about what these things are in law, and as the sovereign men and women that we are, this is nothing more than an unconditional order to pay a sum of money, right? This is a negotiable instrument. Okay. So we all know what that is. And we understand about it. And there's a few different ways we can go about this, but what happens when you follow the law, but the other side doesn't? Do we just go straight to court? Do we just go straight to suing them? This is kind of one of those, this was that aha moment that I had this week. And, it kind of goes full circle for me, because when we started this thing, and I should say when Justice told me I needed to start this thing, back when we first met, and she created our first website and she created the Telegram channel, it was under the name of Affidavits 101, right? And it just resonated with me. It's like there was something about putting your truth for pen to paper and signing your name in front of a third-party disinterested witness that what you said on that paper was true. There was just something that resonated with that. I mean, does that resonate with you guys as well, Erica?
Yep.
So this was kind of that full circle. And you guys know, those of you who have followed our show for a while know that there was a mass, I don't know if I call it infighting, but boy, there was a lot of, no, this isn't right. No, this isn't right. This is how you do. These mean nothing. Blah, 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 blah. There was a lot of this pulling and pushing back and forth. And as those of us who are patriots, yes, there's the book right there. So, Rick, congratulations. Your Rights, Your Voice, the ultimate handbook for empowered citizenship. There's a forward in the book from both Erica and I. Hers is a heck of a lot better than mine, just by the way. So it's up on Amazon, and I believe, correct us if I'm wrong, Rick, but I believe paperback is available.
Today's the release date.
Oh, today. Okay.
Yep,
even
I've
better.
got it in my cart.
That is awesome. So there's the link right there to Amazon. For those of you who are listening, it is the name of the book is Your Rights, Your Voice, and it's written by Richard Moore. Yep, Your Rights, Your Voice, written by Richard Moore, and it's available on Amazon today. You can download it or you can purchase the paperback. So I'm old-fashioned. I like the hard copies, and I know that Rick said he's sending some to us. So anyway.
And it's in the Telegram chat too. It's linked, and there's some info, a little bit more info. He posted a couple of times, and
yeah. So we'll put the link to his book in our description below the video for those of you who are watching on YouTube or whatever, Rumble, wherever it is you're finding our content, and then that way you guys can go check it out. It's a good book. So anyway, yeah, going back to the whole full circle thing, right? So we started down this journey with affidavits. What is an affidavit? What does it do? How does it work? And it just seemed to like resonate with my soul, like Erica says, resonates with my soul.
Me too.
And I never really put two and two together. And then as we started going on, learning how to write lawsuits, litigate, things of that nature, then there was, I don't know what we want to call it, whether misinformation. I don't even know if I like that word, misinformation.
It's so
I just honestly, I think I'm done. Yeah, I know. I think I'm done with all of it. But then there was some prominent individuals in the notices, lawful notices movement, and then there was prominent individuals in lawsuits movement that were going back and forth with each other. Oh, affidavits are a waste of time. There's blah, blah, blah. They were fighting back and forth. I don't remember how long it went because I only listened for 10 minutes before I had to turn it off. I couldn't stand listening to the bickering. Mm-hmm. But it still just didn't make any sense to me, because your heart tells you that an affidavit where you stand on your truth and you not dare, but you invite the other side to stand on their truth and their principles. And if you're wrong, if I'm wrong, show me how I'm wrong and tell me point for point exactly where I'm wrong. Doesn't that just seem like it makes sense, you guys? Am I missing something?
Nope.
That was how our country was founded, on integral principle.
And it eliminates all the trickery and the word magic that they try to use to twist you in their courts.
So I'm glad you went there, Erica, because this was my aha moment this last couple of weeks. This was that missing piece. Now, you guys all know that I've taken cases to courts. I've been less than successful in some cases. Others I've been successful in, but I haven't been as successful as I wanted to be in a lot of these situations. And I finally figured it out that it all has to come down to the way that the courts operate today, the predominant jurisdiction that they operate under, and this principle of honor. And honor could be equated to equity. Equity is honor. So if I'm standing in honor and I'm willing to put my skin in the game, and I'm willing to swear that this truth is my truth, and if I'm wrong and you can prove I'm wrong, I'm willing to go to jail. Is that not the highest? Am I wrong in that, you guys?
Yep.
I am wrong?
No, you're not wrong.
I'm not wrong.
It's skipped out.
Okay.
So,
there was a weird delay on your end.
Yeah. So we were guessing what you might have said there a little bit.
Oh, sorry about that. It's freaking internet out here. So anyway, so the point that I'm trying to make is that if we go to the courts and we show the courts that we did everything in our power to stand in honor, and we come to the courts with clean hands, but our opponent is refused to stand in honor, and now they feel like that they can just walk all over us, which of those two situations are courts today operating under statutory law and equity going to be more likely to rule for? And I'll give you an example. If both sides go to the court claiming this and that, it's a he said, she said situation. The court has no way of determining exactly who has the clean hands in the situation, and they're going to side with the bar attorney every freaking time, which is exactly what's happened to me personally. So I recently came across this document, and this was kind of an aha moment for me. I'm going to share this, and then we're going to talk, get into the case at hand about vacating the void judgment. But this particular document was eye-opening for me. There's some things in here, again, there's some terminology in here that I don't typically agree with, but it doesn't change the fact of what it really is. And this is talking about the private administrative process. This is This is the standing in honor between man and man, or man and woman, and woman and woman. This is what this is. So we have to know and understand that we live in a world of contracts. We live in a world of commercial processes. Everything is contracts. Everything is commercial. And when you're on the commercial side, there are things called unilateral contracts, things called.
You froze, James. He frozen.
Sorry, I'm back.
It's okay.
Stupid. They're doing some work over here, and I really hope they're putting in fiber. Anyway, where did I get cut off?
The contracts.
Contracts.
Can you zoom
Being in
it
the
just a
commercial
bit?
side.
Whoops, not that much. Is that better?
Yeah. Let's see if we move us down here. There we go.
Okay. So we live in a world of contracts. Everything is a contract. When you leave your house, and you talk and you start going to the grocery store, you're contracting with the store to provide you goods and services. Everything is a contract.
Right.
Whether it's written or verbal, it doesn't matter. It's a contract. And so this is the commercial process that we live. And it's created entirely in the realm of fiction, right? We've seen that before, fiction. And it's what it is. It's operating as private law and private contracts between legal fictions, creations of the government. So this is the operational jurisdiction. It's private law, but it's being called public policy. We've heard that before, right? Public policy. So it's not a public law as existed in our republic previously. So this is a fascinating document, one that I think you guys should read. I think we will post this. Actually, I don't think. I will post this in our Telegram chat. But here is the eye-opening thing for me. It's right up here at the top. It says, in order to properly bring or deal with an action in the public sector, the private administrative remedies must properly be exhausted first. I'm going to read that again. The private administrative remedies must properly be exhausted first. The real being cannot perfect his claim and assert any standing as a creditor in the absence of perfecting the private administrative process, hereinafter PAP, private administrative process. So when you take a case to a court, and let's just say it's a debt collector who's suing you for something, all that the judge says is, well, there's a debt that's claimed, that's owed, and somebody owes the debt. Somebody's going to have to pay the debt. Bless you, whoever that was. They don't they don't care whether it's a valid debt or not. So they're just saying somebody claims that there's a debt that's owing and somebody has to pay it. So we can't go into court claiming that we don't owe anything or claiming that we have standing as a creditor if we can't show that we went through that process. And this is the key. Courts today, all courts today, are admiralty/equity tribunals. We've heard of admiralty, right? Admiralty is nothing more than statutes, statutory laws. This is what these lawyers and attorneys swim in. The Admiralty Statutory Sea. That's what they know. That's what they love. That's how they try to trick people. That's how they enslave people. That's how they do all of it.
Oh, yeah.
So if we're going to play their game by their rules, right? What's our motto to our new association? Learning how to use public laws for our private gain.
For our private rights.
For private rights. So if we're going to play the game according to their rules and their procedures, well, then we have to go and show the court that we exhausted all of our administrative remedies first. So I'm going to talk a little bit more about what that process looks like on another episode. But really, these are the maxims of equity that are crucial, and it makes so much sense, so much more sense, that if you read through these maxims, if you're contemplating taking a case to small claims court or a regular court, whatever, if you read these maxims and you can say, yes, this is me in every single one of these, then you're golden. So the first one says, he who comes into a court of equity must come with clean hands. You cannot go into a court, and I'll use the example as a debt collector, right? So a debt collector sends a demand asking or claiming that you owe a debt, and you request verification and validation. They don't provide that, and then they sue you to try and get you to pay. Does that debt collector have clean hands?
No.
Mm-mm.
No, because you operated in equity, you operated in honor, and requested proof of claim outside of the court. What's that, Justice?
Sounds like the mortgage companies.
Mm-hmm.
That's what they do.
Mm-hmm. So, on the flip side of things, if you are the defendant or if you're taking action and you're the plaintiff, and you can show the court, as soon as I received notification, I requested verification. No such verification was given to me. I requested a second time. No such verification was given to me. I requested a third time. No such verification was given to me. Who's got clean hands in that case?
Right.
You
I
do.
mean, I'm a big, I'm a biblical follower of Christ's law, and for me, everything is done in threes. It just makes sense. I'll give you 3 chances to do the right thing. 3 chances. If you can't within 3, then you're showing me that you're not an honorable person and you're not standing in honor. This is how we stand in honor. You all right there, Justice?
Yeah, I'm going to mute and choke for a minute.
So the second one is, he who has committed iniquity shall not have equity. So I'll give you a good example. And this happens all the time. Eric, I can't remember, is Indiana a state that allows non-judicial foreclosures?
Yes.
Okay, this is huge. Okay, this is huge. Generally speaking, non-judicial foreclosing states require the party that wants to initiate a foreclosure to send a notice of default to the alleged debtor first. Usually it's required that there's some type of an attorney, and that attorney will send you some type of a letter that says, I represent so-and-so, you owe this debt, this is an attempt to collect the debt from a debt collector, something of that nature, right? So when you, as the consumer, request verification and validation from that attorney of this alleged debt, and they don't provide that, because again, what's the definition of verification? Let's make sure we have these terms clear. Well, under Black's Law Dictionary, verification is verifying and swearing under oath or affirmation that the information is true. I would defy anybody to find a debt collector that has ever done that when a consumer has requested verification and validation of the debt.
No, they just send you your original document.
They send you copies.
Yeah.
Of your original document. They send you copies. So they have committed iniquity because they have not followed the law as it's written. Also, the law specifically states that they are to cease all collection activities until they have obtained verification. So verification, the way I understand that, is it can come from one of 2 forms. It can either come from the debt collector themselves, or it can come from whichever party that they're representing. Somebody has to swear under the pains and penalties of perjury that there is a debt owed and that you are the one who owes that debt. They never do. They have committed inequity. So they shall not have equity. But what do? They ignore everything, and they go ahead and file in these non-judicial states. They file a notice of default at the county recorder's office. And depending on the state, it can be anywhere from 45 to 60 to 90 days that they have to wait. Then they file a notice of trustee sale or something of that nature, and then they sell the property. Again, did anybody get due process of law there? No. And they have committed inequity, but they're trying to have equity. They can't. This is the third maxim. Equity denotes the spirit of habit and fairness, justness, and right dealing, which would regulate the intercourse of men with men. Again, this is This is what we were talking about from the very beginning, Justice. Does this sound familiar, right? When we started talking about affidavits and why we send affidavits, and it's all right here under the equity. And I just didn't know it at the time. Number 4, equity suffers no right without a remedy. And that's true. Equality is equity. Number 5, equity follows the law. Number 6. Number 7, he who seeks equity must do equity. That's what we do when we exhaust our administrative process. He who seeks equity must have clean hands. We talked about that up here. Equity will not permit a party to profit by his own wrong. So, wait a minute. I can't. I know, except all
in
these
this lady's
people.
yeah. Except in this case, the court's blessing, right?
Yeah. So, Sasheka, and I apologize if I'm Sasheka. I apologize if I'm probably brutalizing that name. I apologize. How do we overcome that? Well, I'm going to talk in a future episode about the administrative process and how it works, and how we, as the honorable men and women that we are, we send notices, we send affidavits, swearing under pains and penalties of perjury. And see, here's the thing: if these people can force us into unilateral contracts and make them enforceable in a court of law, not a court at law, but a court of law, okay, then what is it to say that we can't do the same thing? Well, we absolutely can. It's taking off your private hat, putting on your public hat, and you're writing these notices, and you're invoking acquiescence. Silence is acquiescence. Okay? There's a reason why in the court rules that he who does not deny admits. So if you don't deny it, it's admitted. If you don't come back, it's admitted. There's a reason why that's there. And if it violates the common law, which is the common sense of, wait a minute, if somebody is making these claims against me, these are some pretty serious claims. I need to defend my honor.
Mm-hmm. And only the one in honor can rebut the claims made against them.
Exactly. So this is why they never, I have yet, to this day, I have sent out, I don't know how many affidavits. With court filings and outside of court. I don't know how many times I've done that. And not one has ever been rebutted. Not one.
Not either.
Not a one. So to answer your question, the process is that we put them into a corner, and then we take all of our evidence. And again, I go by 3s. That's just me. You don't have to go by 3s, but I feel like that's stronger, right? I feel like the more we can show to the court that we stood in honor and we provided equity, and we were asking for equity in return, but all we got was a slap in the face. So if we can go to the court and show all of that, and we can say, hey, judge, I gave them 3 opportunities. They chose to ignore me. I took my evidence to a notary public, presented it to the notary, and I got a certificate of dishonor from the notary public. That is a default judgment in the private through a public process. Now I take that information and I incorporate that into my court case. Now what's that individual on the other side going to say? Well, I wasn't required to file, or I wasn't required to respond to any of this stuff. It's like, well, hold on a second here, dude. The notary public was a third-party disinterested witness. They have now verified, just like I would as a judge, that you are at fault. That's what I think has been the missing piece that we've all been struggling to find. So that was just kind of my little 2 cents there. But what are your thoughts on that, guys?
I have been working with several research partners trying to get to the bottom of what are we missing here? Because is the truth not enough? Like mm-hmm. in my spirit, it's just like I should be able to say, this is what the truth is now, and here's what the law is. So now rule it according to the truth and the law. Mm-hmm. That doesn't happen for some reason. It's like they're a part of some sort of hidden knowledge that the rest of us aren't. But yeah, this could very well be that.
Well, it's corruption, plain and simple. It's not hidden knowledge. It's just that they have the power. And I mean, let's not even, talk about whatever oaths they might take and whatever secret clubs they belong to. And they're all for one another, and kickbacks they're getting. I mean, they're exposing it now. The judicial kickbacks. I mean, Trump is exposing it, but it's pure corruption, because it isn't based in common law and right and wrong and juries anymore. It's based on, how do I benefit and who's paying me the most? And that's who I'm going to side with, really, in a nutshell. Obviously, it's more detailed than that, but that's what I see. I just see it as pure corruption. You could beat your head against the wall with proper technique and, proper procedure, and they'll just ignore it if it benefits them. Not all of them, but by and large, it's what we see.
Yeah, no, you're absolutely right. I mean, this is. I was listening to a podcast where these gentlemen were talking about the three overarching jurisdictions that make up the acronym of law, right? Land, air, water. We've heard of that before. They were talking about air. The air jurisdiction is ecclesiastical. This is trust law. This is private trust. It's like getting your stuff, your property, out of those sticky hands. Then they talked about land, which is common law, which we all know about. Then they talked about water. And the reason why admiralty and maritime jurisdictions is mentioned in the federal constitution is the waterways was how commerce was done back in the day. They didn't, the way to transport mass goods was over by ships, by boats, up and down the rivers. They didn't have highways and interstate highways with semi trucks, obviously. So.
And there are schools of thought that get really out of whack with that combine a lot of the patriot mythology stuff that we talk about, but really having a good understanding of the public and the private is really key to having success in all of this, I think.
Yeah. So Bill brings up a good question. He says, isn't the notary public merely witnessing that your identification is valid and you are the person who signed the form? Yes. However, Rick, our good buddy, just answered the question for you right here. So Rick says, let me get to it. Rick says the notary becomes a witness to your true statements. The notary is a jurat. So what that means is the notary could be, if it's ever taken into court, the notary could be deposed. They could be brought into court. They could be sworn. And they could ask the questions like, well, wait a minute, did on such and such day, did the plaintiff show you all these things that they claim they showed you? It's like, he did. Did the plaintiff swear to you that he received nothing? He did. Okay. I mean, what's there to testify? What can the notary do other than just say, yeah, he showed me that he made the effort, but the other side failed to rebut it.
All right.
Yes.
And then let's read that for our podcast friends.
Yeah. So Alexandra Sunshine, I love the name, by the way. She says, yes, Rick, yes, the notary is merely a witness to the statement, but he or she does not confirm truth or falsity. That is also true. It's not their job to confirm what you're saying is true or not. It's only their job to witness your signature. And it's no different than if you're sitting in a courtroom and the judge says, I'm going to put you under oath. Is it the judge's job to verify the or confirm the truth or the falsity of your statements? No, it's not. It's just you're put under oath. That's all you're doing. And that's why this is such a powerful process. And it's one that I think it's been around for years. But I think the reason why people don't know about it is because of how powerful it is. And it scares the pants off of these stupid lawyers and attorneys because they know they don't have a leg to stand on.
They acknowledge the power of the affidavit too, like in the process, because we didn't do any paperwork for our son. Now that we're wise to everything, we didn't do any registrations of any kind. So I was like, well, what if he wants to travel someday? So I looked up the process for getting a passport.
All you need is
affidavit. Yeah, and I can.
All you need is an affidavit of birth. Yeah. Yep. And you absolutely can. And see, here's the thing is people want to lie to you. He doesn't need a social, that kid is going to be set for life. He doesn't have to have a social security card. He doesn't have to have any of that other crap. All he needs is a passport.
And he's going to know about contract law.
He's going to know all about contract law.
Here's me talk about it all day long now.
It's actually illegal. And there's a difference between unlawful and illegal. Just remember that. But under federal law, under federal statutory law, employers are prohibited from requesting your social security number, but they do it all the time. And they say they have to do it because the government makes us do it. But,
Yeah.
well, you can't have your cake and eat it too. I mean,
Right.
you try, but it's not going to work. So,
Yeah, we've not been a free people for a long time, and people don't realize it.
Yeah.
You're waking
So
up in droves, though.
I think we already answered this question, Alexandra. How does the notary confirm whether the statements are true or not? And then her very next one, she says, thank you. Yeah, like we said, it's not the notary's job to confirm the truthfulness. All they're going to ask you is, do you swear under oath that what's on this piece of paper is true? And you're going to say yes. Again, so there's actually three witnesses to that signature, right? There's you, there's the notary, and there's God. That is the power of affidavits.
Yeah.
So we need to get back to the basics, and that's what we're going to be teaching, and that's what our membership is going to be focused on. So, yeah, Justice,
were you going to share about your case?
Mm-hmm.
Okay. I love these conversations.
I do too.
But sometimes we got to cut them short.
I know, and I want to make sure that we get right on with it. So this is let me blow this one up a little bit too. All right. So some of you guys know about the situation here with a friend of mine here locally. Just for by way of backstory, he stood up to the tyranny that was going on a few years ago and went to a town council meeting or something of that nature and let his opinion be known. And so the council took it upon themselves to make an example out of him. They came after him. They prosecuted him civilly for violations of city code, which we all know who that really applies to, right? And he went through this whole process. While this was going on, he reached out to me. I told him I'd help him out as best I could. He was served with a lawsuit. We filed a properly filed motion to dismiss, which we're going to talk about here in a minute. The judge ruled against us, didn't even give him a hearing, just ruled against us, didn't even say what the reasons why he ruled against us. He said, it's just denied. Then they proceeded to steamroll through this process. They filed a motion for summary judgment. The rules require an affidavit in support of the summary judgment. Well, the individual who signed the affidavit for summary judgment doesn't even work for the city that was suing. He works for the county. But in the affidavit, he states, mind you, he swore this under penalty of perjury, that he performed an inspection on the property. Now, remember that. All right, so then we go through this process. They issue the judgment, and I said, you know what? We're not going to play these games. Let's sue these people in a different court, and let's sue them for to have a petition to vacate a void judgment, and that's what we did up here. So this is titled right here, in the nature of a collateral attack to vacate a void judgment, and this is the case that we're voiding right here. So as I go through this, I just want to touch on a couple of things that is interesting. So one of them, and again, you guys all know, or maybe you don't know, but I'm really a big fan of Richard Cornforth and his documentation. So this was mimicked after him. So this mandatory judicial notice was almost copied and pasted word for word from one of his petitions to vacate a void judgment. And I love the fact that how we bring it back down to say, hey, court, you don't get a discretionary duty on this. You don't get to choose whether or not you're going to grant this. Your hands are tied. You must grant this. So we put this out there. The court has noticed that, one, the party petitioning to vacate a void judgment is proceeding via a collateral attack. 2, party collaterally attacking a void judgment is invoking the ministerial side of the court. The court is deprived of judicial discretion. Number 3, party asserting that the court had jurisdiction has the burden of proof to show on the record that the court had jurisdiction. And 4, where the face of the record verifies jurisdictional failings, the court has a non-discretionary duty to vacate the void judgment. All right. So we go down here. This is the name of the people that were coming after him. They were the putative plaintiff in this case. They had no standing to bring alleged violations of the Municipal Land Use Development and Management Act, which is designed exclusively for what, you guys? Creations of who? The government, not the people. Under this code here, for the reason that MMT, which is just Magna Metro Township, never offered credible evidence that the plaintiffs in this instant case had any nexus or contractual relationship with MMT, nor that the plaintiffs fell squarely within the meaning of persons, as that term is defined within the definitions of this act. All defendants in this instant matter were properly notified of this jurisdictional failing, yet chose to pursue this action, notwithstanding the court being without jurisdiction to enforce or to issue any enforceable ruling. MMT had a mandatory duty to show to the court that it had standing under the traditional doctrine of standing or under the doctrine of public interest to pursue the action taken against the plaintiffs prior to any ruling from the court. Despite being notified multiple times, MMT refused to show that it had standing in either sense of the definition to bring the action they did, supporting their action with admissible testimony from a competent fact witness. There's no testimony from any fact witness in that original case. Notwithstanding this jurisdictional defect, the court chose to ignore the failings pointed out by the plaintiffs and proceeded to issue void rulings in denying plaintiffs' motions to dismiss and granting MMT's motion for summary judgment. MMT has refused to produce a competent fact witness proving it had traditional standing or public interest standing to bring an action under this act, thereby admitting that it did not have standing and had no authority to bring the action against the plaintiffs to begin with. Is that pretty clear?
Yeah. So let's say he signed some kind of contract when he bought his house. That would give them standing, right?
No, it would not.
Okay. So what would be standing then in this case?
He would have to have a specific contract with the municipality stating that he agrees and understands that he will adhere to all of their building codes and ordinances or whatever else.
Like CCRs in a homeowner association.
Very similar. Yep.
Otherwise, all private rights and private property are accepted out of the government's ability to legislate on any of it.
Yeah. So I want to touch on this question here from Rise of the Republic. What if the damage was done 15 years ago? Is there still remedy without being barred by statute of limitations? Yeah. You can, anytime the court is deprived of subject matter jurisdiction, which is the overarching jurisdiction of the case, you can go in and petition to have that judgment vacated. It doesn't matter if the case is 60 years old. It
doesn't matter if you've done time for it. It doesn't matter at what point in the sentencing you are. Yeah.
Yep. Yeah, Brandon, you're on the right track. There's no statute of limitations for fraud. You're absolutely right. Because again, inequity will not, you cannot commit inequity and receive equity. So the court or the people who committed fraud upon the court are asking the court to grant them equity, but they can't. It just does. It won't. The scales of justice are going to be tipped unfairly in favor of them, and they can't. It's not sustainable. It won't work.
And just the words, the statute of limitations. Statutes are not the law. Like at any time, if the people are violated in their rights, there's never a time frame that it has to be addressed within in order to receive remedy.
Yeah. So I want to touch on a couple of things here, and then I'm going to talk about where we are with this case because it's fascinating. So real simple, you guys, and again, I believe I posted this in our group, but like, this is part of the other reason why we're doing our association. We're doing the website. Everything that I write up, every lawsuit that I write up or help people with motions, whatever, those are all going to go into our documents and resources tab. And so if you're a member of the association, you'll have access to all of it. You can download it. You can plagiarize it. Please do. That would be flattered if you did. You can take all of that stuff, use it for your personal situations. That's what we were. That's
Right.
what we're trying to accomplish.
And it's a
Now-
level of protection for you.
Exactly.
Yeah.
Exactly. So now these types of lawsuits where we're attacking a void judgment in another venue are procedurally different than a typical lawsuit where the judge is afforded discretion to determine the facts that are being presented before him by the parties. In this case, no, his discretionary use, his hands are tied. He has to look at the record. And if there isn't something on the record that clearly shows the party that was granted the void judgment had jurisdiction, he has to overturn it. He doesn't have a choice. So that's what we said here. The record shows that the defendant failed to prove up jurisdiction when challenged to do so by the plaintiffs through a procedurally correct filing of a motion to dismiss under Rule 12b-1 and 12b-6. So 12b-1 is for lack of jurisdiction, particularly subject matter jurisdiction. Furthermore, in response to plaintiff's motion, defendants filed a request to submit for decision wherein a hearing on the matter was requested. So under this rule here, when a hearing is requested, it must be granted unless the issues raised in the motion are frivolous or authoritatively settled. Okay, that's key. Defendant Kelly, who was the judge in the original case, denied the motion without granting the hearing, citing this rule as his precedent for doing so, but failed to cite or quote any authoritative rulings that would clearly show that the arguments raised by the plaintiff in its motion were authoritatively settled. He just denied it.
He just said denied.
He just said denied. Okay. Under court precedent from either the Utah Supreme Court or the Utah Courts of Appeals, absent including findings with rulings that clearly show the arguments raised by the plaintiffs were authoritatively settled, Kelly violated plaintiffs' due process rights, and subsequently the court lost any jurisdiction it may have had up until that point.
Will you also file a judicial complaint on him?
Yeah. Well, I don't know. It's up to my buddy who's going through this. Additionally, the record shows that when defendants moved for summary judgment by and through their defendants' counsel, there were no answers to interrogatories, depositions, admissions, or declarations or affidavits submitted by the defendants. And in fact, plaintiffs filed a procedurally proper answer with affirmative defenses supported by affidavit from each of the named plaintiffs here, affirmatively denying each claim set forth by the defendants. The record shows that the only documentation filed in response by defendants was the initial disclosures and then a motion for summary judgment. Number 9, plaintiffs filed an opposition to their motion for summary judgment and set out material facts of
dispute support again by declaration swearing under the pains and penalties of perjury that genuine material facts remain and the defendants MMT and PS were not entitled to summary judgment. Still frozen, James? We lost James.
They filed no counter affidavits in response, nor any affidavits or declarations in support of their motion for summary judgment. No hearing was requested, nor was a hearing held. And notwithstanding this information, Kelly granted the defendant the motion for summary judgment. What a crook. I mean, and he's outlining it so clearly too. So
it's so interesting that these guys can just completely disregard the law and get away with it.
Not for long, sister.
Nope.
So,
oh, you're frozen again, James. We heard a robotic. There you go. You're back. You're back. Okay.
What about now?
You need your document back now. Yeah.
I'm sorry.
That's okay.
I'm so sorry. Freaking internet out here is terrible. So, all right. There we go.
Okay.
All right. So, anyway, there was no hearing that was granted, not even on the summary judgment.
We got through 10. So,
yeah, we're right here.
11.
Yep.
Defendant Kelly is not free to utterly ignore duly submitted evidence on the record, nor is he free to ignore the lack of evidence that the defendants had standing to proceed with the lawsuit or the summary judgment. Kelly's oath of office requires Kelly to be impartial and to do substantial justice. And it does not permit Kelly to wrongfully grant judgment to a party that has failed to properly invoke the court's jurisdiction by the sufficiency of the pleadings before the court. Kelly had no basis to ignore plaintiff's answer and affirmative defenses filed on the record properly supported by sworn testimony. By ignoring this sworn testimony, Kelly violated the plaintiff's due process rights and aided and abetted the defendants in their continued fraud upon the court, abuse of process, and trespass against plaintiff's rights. So then we talk about the stupid attorneys. They were giving Grant ample notice, and how all of this stuff is prima facie evidence that that they done screwed up. So let me stop sharing my screen. Let's talk about where this case is now. So remember how I said they filed a summary judgment motion, and their affidavit that was supporting it was by this guy who said he performed an inspection on the property. Well, while this was all going on, after he received, or after this other case was judgment was issued in the defendant's favor, my buddy filed a criminal complaint with the local district attorney and claiming trespass on his property. Because somebody swore under oath that they performed an inspection on his property without a warrant. Oh, the look on Erica's face. It gets better, Erica. Just wait. So there is, what's funny is when this judgment was granted, the city sent people out to determine how much it would cost the city to tear this guy's, it's a garage thing, a carport. That they wanted to know how much it would cost to tear that off his house, and some solar panels too. So they sent somebody out there, and there was a law enforcement officer who was there, and he's shaking his head going, I don't understand what these people are doing. He says, I'm looking around this neighborhood. The guy lives in a cul-de-sac. He says, I'm looking around this neighborhood, and I see 5 other houses that have code violations, and they're not doing anything about it to them. And he's like, yeah, I know.
The police officer?
Yeah, the police officer said that. So he also said, I see that you filed a criminal complaint for trespassing on your property. He says, I've been assigned to that case. So this officer proceeds to interview people, and he interviews the gentleman who swore that he performed an inspection on his property. Guess what the gentleman said?
What?
I didn't do it.
I never stepped foot on his property. Never even went out there. Rise of the Republic. You're absolutely right. They
What
are
exactly
a blast.
are the pains and penalties of perjury?
Exactly. Criminal complaints are a blast. Rise of the Republic hits the nail on the head. So here's what happens. Okay. So we file this suit. The law requires you to file the suit wherever the stuff happens. Unfortunately, where he lives is in the same district court of where this void judgment was issued, but it doesn't stop us from filing a new suit to try and get a different judge. So that's what we do. Well, the people at the county courthouse, I don't know if they've ever seen this before, or if they have, they've never encountered it the way that we've done it. They didn't know what to do. They're like, what am we supposed to do with this? You're suing one of our judges? We're like, yeah. The guy issued a void judgment. We're suing him. Yeah. And they didn't know what to do. So they sat on it for a few days. And then, from what I understand, every single judge in that district court recused themselves. Every single one. So every single judge recused themselves. So then what they do is they transfer the case from that district court up north to where I'm at. And 3 judges here recuse themselves. Until finally one judge stands up and says, yeah, I'll take this case. And I actually happen to know this judge. I had dealings with him before, way long time ago, before I had any clue about any of this stuff. And he's an honorable man. So he took the case. Well, when you file a new lawsuit, the other side has 21 days to respond. So what does the other side do? Everybody except for Judge Kelly files a motion to dismiss based off of the other suit that was filed, and blah, 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 blah. Well, I thought it was kind of strange that the judge, who's really the entire thing revolves around the judge, he never bothered to answer the lawsuit. Not within the 21 days, not within 30 days, not within 60 days. We waited 60 days.
Wow.
And he didn't even bother to file anything into the case. So Last week, we filed a motion for default judgment against the judge, and we only named the judge, not the others, because they responded. But this is what's so funny about all of this. Once that default judgment is granted, their entire case falls apart. All of their arguments are moot.
Mm-hmm.
We don't need it. And the very next day, so he files this motion for default judgment. The very next day, a couple of the people that we're suing that are representing the city, they file a motion into the old case, voluntarily dismissing their remaining claims. I don't find that a coincidence at all. Do you guys?
Wow.
The rats are scattering.
Mm-hmm.
Uh-huh. So, and then not only that, my buddy, he's got this criminal investigation that's still going on. This guy perjured himself. They're in a world of trouble. They are in a world of trouble.
This is what happens when the people learn the law.
Mm-hmm.
And take
And
a
all we
stand
did-
for themselves. Yeah.
Exactly.
They have
And
nothing to stand it on.
you know, and I'm grateful that it happened at the lower court levels. I told my buddy, I said, hey, listen, hope for the best, expect the worst. We're expecting that everybody here is going to railroad you and say this is above board. It's fine. There's nothing wrong. But I was like, I'm happy it happened this way. I look at it I'm kind of reading between the lines here without knowing what's really going on. And my thought process is that this judge, the original one, is going, hey, I have to keep up appearances, which is why I did what I did. But since you sued me in another court, I'm just going to not answer the suit. So then you can get a default judgment, which wipes out my ruling in the other one. So I can still keep up appearances, but you get what you want and everybody goes home.
Yeah, and he doesn't have to eat crow in front of anybody.
Mm-hmm.
Mm-hmm. So that's what happened. And that's where we are with that case. So
It's exciting.
we filed for the motion for default judgment. We got to wait 14 days, which will be, I think, this Thursday or Friday. And then we can actually file to have the court grant it.
That's great.
So
that's great. Tables are turning.
Yep. So that's where we are.
Tables are turning. So tired of hearing people get railroaded.
Yep. Yeah. Me too.
Someone has a message for you, James. They got something to share with you, so reach out to them, Brent Gray.
Yeah, I saw that. Yep. Utah State Legislature. Brent, I do want to talk. Send me Brent, if you're on Telegram, send me a DM on Telegram, will you? Just so that way we can get in touch. But so anyway, that's what I wanted to cover today, those two things. I do want to go into more detail, the administrative process. We'll do that on another episode. You know, maybe we have a guest coming on for next week. One that one that Erica has worked hard to procure for us.
He's been on before, right?
Yep, he's been on before. Brent Johnson. He's coming on next Friday. It's going to be a little later. It'll be 3 p.m. Eastern time, 1 p.m. Mountain Standard Time. And we're going to be talking about a number of different things. We'll also bring up this administrative process here. But again, at the end of the day, it's we have got to show the court that we stood in honor. We gave the other side every opportunity to stand in honor. And when they chose not to, but they still want to steal from us, well, now who's the scales of justice are imbalanced, and we have to rebalance them. And equity there is no equity at that point. So we have to bring it back. So I'm going to keep the show shorter today. Like I said, just about an hour. We are right at smack dab at an hour. So with that, I'm going to leave it to Erica and Justice for any last closing remarks, thoughts?
I just love you guys. You're all here to learn, and you're just like, the more of us that learn, the more of us that have success. So I'm so glad you guys are here and watching.
Mm-hmm.
Keep fighting, keep learning.
Yeah. Some quicker than others.
Yep. All right,
okay,
you guys.
So,
well, with that, I'm going to sign us off. Oh, go ahead, Justice. Sorry.
I was going to say, happy Valentine's Day, everybody. Enjoy loving on your loved ones, and we'll see you next time. We'll keep you posted in the chat about the website.
Okay.
Okay, bye.
Bye.
Until then, you guys have a